Thank you, Madam Chair. My name is NGcukai Tobi. I'm an advocate in Johannesburg. I am in this matter with Mr. Ramohale and Ms. Sekwe, S-O-E-K-O-E. We act on behalf of Mr. MALEMA, Mr. Shivambu, Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo. I presume that they are all present. Mr. MALEMA has already announced himself, and I've seen the name of Mr. Shivambu on the screen. And perhaps we should simply ask Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo to confirm their presence, because I've not personally seen them.
Can you do so, honorable members, as requested by Advocate NGcukai Tobi?
Thank you very much,
Just
Chair.
to confirm.
Pambo. Thank you very much, Chairperson. Guyani Pambo here. I'm present.
Thank you.
Chair, I'm present, Marshal Dlamini.
Thank you, Dlamini.
That leaves Tambo and Mr. Ndlozi.
Thank you.
Chairperson, I'm here, Ndlozi.
Thank you.
Thank you, Madam Chair. If I may then proceed, there are two applications that we've indicated we intend making. The first application is for the committee to appoint an independent chairperson who might either be a judge, a senior attorney, or a senior advocate to conduct the fact-finding inquiry, and the matter will then be remitted back to the committee for its final determination. That's the first application. The second application is for these proceedings to be postponed to either a date or dates in January or February. We will be indicating to our learned friends the week in January or February that would be suitable. Let me start with the first application, which is the appointment of an independent chairperson to conduct the fact-finding inquiry. Firstly, the committee is bound by the common law rule against bias. Now, we don't accuse the committee of bias, but what we say is that the common law rule against bias means that you as a committee cannot be a judge in your own cause, and that it is important that there should be no perception, reasonable perception, that you are biased against the EFF. Secondly, you are bound by the provisions of Section 12 of the Powers and Privileges Act. Those provisions require you to ensure that the proceedings are reasonable and procedurally fair. We say that the only way to ensure that there is reasonableness and procedural fairness is that you should appoint an independent chairperson to conduct the fact-finding inquiry. And thirdly, you are bound by the Constitution, and I did not say that, it's obvious. But the requirements in Section 1C of the Constitution require you to ensure that you act rationally. And we say that the only way to act rationally in these instances is to appoint an independent fact finder. So let me start then with the first of those three propositions, the rule against bias. Now, the rule against bias is part and parcel of the common law rule of audi alteram partem, which is generally referred to as the natural justice. What it contains are two elements. The first element is that you should give a hearing to an affected party. Obviously, you are giving us a hearing. We are not objecting to that. But the second one is that the person who hears the matter should not be biased and should not be reasonably perceived to be biased. The problem that you have as this committee is that you are majority, according to the calculations of my learned colleague, you are 61% ANC members. You are sitting in judgment of your political opponents, the EFF. You therefore hold enormous power over your political opponents. And the issue at stake is a political issue. You have obviously framed it, or the prosecutor has framed it as a breach of the rules. But what is clear is that on the 9th of February 2023, there was a protest by the EFF against its political opponent, the President of the Republic of South Africa. Now, you may disagree with my framing of the issue, but that disagreement is of no moment, because what we argue is that the person who makes a judgment against the EFF must not only be independent, but must also be perceived to be independent. So we ask yourself, we ask you to ask yourself the question whether any reasonable member of the South African public will perceive a hearing in which the ANC stands in judgment against the EFF as an independent hearing, particularly at the fact-finding stage. Now, this is not the same issue as presenting a bill for voting in Parliament, where majoritarianism applies. And this is not the same issue as deciding whether or not the public protector should be impeached, where again majoritarianism applies. This is an issue whether or not political opponents of the ANC in Parliament should be judged by the ANC. And it has severe consequences, not merely among the people that I represent, it has severe consequences among the voters. The effect of the matter is that some people in this country, more than 1 million of them, have chosen the EFF to represent them in Parliament. And although when the EFF is here, they are members of Parliament, the Constitution itself recognizes that they are opposition members of Parliament. That is why there is a rule in Parliament that there is a leader of the opposition. It is a recognition that they don't lose their political identity when they become members of Parliament. So we say that if you continue constituting the committee in the current fashion, you will fall foul of the common law rule against bias, and your proceedings will be unlawful and unconstitutional. So that is why we do not ask that the matter should not sit. We've never made that request. But what we do, we ask that the matter should sit before a neutral, independent chairperson to determine whether or not the political opponents of the ANC are guilty of misconduct. The other consequence of this is that if you look at the penalties that may be imposed in terms of the act, the most drastic penalty is a suspension for a period of 30 days. Now, what that means is that the EFF, particularly its leadership, and I act here for the top leadership of the EFF, you can remove them from Parliament for a period of 30 days. And if you were to remove them in Parliament on political grounds, and not necessarily on misconduct, because we say that there will always be a stain that you are biased against the EFF because they are your political opponents. But if you remove them for a period of 30 days, what that means is that during that period, any deliberation, and it may even be a State of the Nation address next year in February, or it may be a deliberation on an important bill. But during that period, a significant part of Parliament that has been voted into by the public would not be able to participate, which means that this is not about Mr. Malema, but it is about the 1 million or so people that have chosen the EFF to be their representative in Parliament. So, argument one, we say that you should remove the stain of perception of bias against yourselves as the members of the ANC. Now, that, of course, does not mean you individually are biased. What it means is that the law regards you on a just perception basis as reasonably biased against the EFF, merely on account of the fact that these are your political opponents. But even if you look at the nature of the charge, it simply strengthens the political bias. This is a charge ostensibly for threatening the president. But this is not just the president of the country. He is also the president of the ANC. You are also members of the ANC, and I accept that you are acting here as parliamentarians. But there is an uneasy feeling that you will protect your own president against the EFF. And that is why you have to remove that perception and appoint an independent person. That person may be a judge, they may be a senior counsel, they may be an attorney. But we cannot see the downside. We cannot see the harm. We cannot see anything that would be harmful to parliamentary autonomy and parliamentary rules if you were to appoint a judge to hear this matter. Section 12 of the Act does not prohibit you from doing so. It does not require you to sit as the disciplinary committee. It merely requires you to ensure that the proceedings are fair and the proceedings are reasonable and the proceedings are rational. And the way to achieve the object of the Act is to appoint a judge to conduct the fact-finding inquiry. So we say, as a matter of the common law, you are obliged to do so. And as a matter of the statute, there is nothing preventing you from appointing a judge to hear this disciplinary hearing. Secondly, are the provisions of the Act itself. I have already explained that those provisions of the Act requires you to ensure that the hearing is procedurally fair and the hearing is reasonable. It is unreasonable, it is procedurally unfair that you should subject the top leadership of the EFF to a disciplinary hearing that is presided over by its own enemy, political opponents. Particularly so because you, as members of parliament, are also witnesses to the incident. You are witnesses to the incident because this happened on the State of the Nation address. You've also made a decision to institute the charges. These charges were not independently instituted, they were instituted by yourselves. You've also made a decision to choose the initiator. And obviously, you've tried to choose the initiator on the grounds that he is independent, which we appreciate. Mr. Katz is an independent man and is a colleague at the bar, and we have a lot of respect for him. That is fine. But what we ask for is that in the same way as you have appointed an independent prosecutor who is truly independent and who is not political, you should also find it in yourselves to appoint an independent judge so that we can debate whether the EFF is guilty or not. There is no benefit to Mr. Katz to sit here and prove a case in front of the same people that are witnesses, same people that have decided to charge the EFF, and same people that will be making the deliberations. So in sum, on this point, you are the judge, prosecutor, and sheriff in one. That is just wrong at so many levels. It's wrong as a matter of constitutional law, it's wrong as a matter of the common law, and it's wrong as a matter of the statute. We have seen the rules that Mr. Katz is permitted to be appointed as a prosecutor, but we say that there is a reason you chose him. You chose him because of his unique characteristic as an independent man, and may I add, also an honorable man. We say you should do the same thing for the appointment of the chairperson. And there is then the third requirement, which is you are bound by Section 1C of the Constitution, and that section requires you to act rationally, and it requires you to act within the scope of your powers. We say the request we've made is within the scope of your powers, but it would also be consistent with the principle of rationality. And if you did not do so, you would be acting irrationally. And it does not mean that you will necessarily find the EFF guilty. You may well find them not guilty. But what you will never remove is the stain that political opponents of the ANC, if they don't please the ANC in parliament, will be subjected to a disciplinary hearing, which ultimately is deleterious to our constitutional order and limits the ability of MPs to be robust when they are inside the precincts of parliament. If the EFF is guilty, as seems to be the view, if Mr. Malema is guilty, let a judge tell him that he is guilty, he will accept that. What is unacceptable is that he should be told by his political opponents who decided that he is guilty, who witnessed that he is guilty, who chose to charge him, and who have a political incentive behind his conviction and the imposition of a penalty against him. So let a judge, let a neutral person, let an advocate, let an attorney make this determination. It is a grave determination, and it should be made independently of yourselves. Now, that, of course, is not to cast an aspersion on you as members of parliament, but it is to state the reality that he cannot expect to have a fair hearing when he is subjected to punishment by his political opponents. So that's the first request. We ask you that you should appoint an independent person, and that person, we say, can be a judge or can be a senior counsel and can be an advocate, an attorney. If you did that, we will be back here in January or February. We will take 3 days or a week. We will finalize this matter, and you will hear no objections from us, at least on the process. And you will get the evidence you want to hear. And if you are confident of your case, you should not fear the subjection of this case before a judge. It is only when you are not confident of the case that you actually want to preserve it for determination by yourselves as politicians.